you have questions about your employment law rights that you need answered, Ask a Lawyer is here for you. Every week, Lecker & Associates disability and employment lawyers are taking your questions on a wide range of employment law topics. Call 1-888-802-2016 or send your questions to askalawyer@cp24.com. Watch Ask a Lawyer every Wednesday at 9:30 p.m. on CP24.
If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer, a call-in show where we take your questions about all things employment law. I'm your host, Dana Levinson. Each week we dive into a different employment-related topic that is on many Canadians' minds. I'd like to welcome my two guests for today, Matthew Fisher, partner with Toronto-based law firm Lecker & Associates, and Kimberly Sabag, associate lawyer with Lecker & Associates. Today we're going to talk about executive severance. As always, we'll be taking questions from Canadians. Matthew, executive severance packages affect a small portion of the workforce. Why is this such a big topic? And how does this trickle down to the average employee?
So it's a very good question, Dana. At the end of the day, Canadians' rights to compensation when they're let go, their rights in employment, aren't strictly siphoned off between whether you're an executive or not. Employees in Canada have rights no matter where they stand in the pyramid of their employment. The difference with executives tends to be one of the overall amounts, in that when we're looking at termination packages, for example, when this really comes up, we're looking largely at three factors: age, length of service, and position. And position is the key factor for an executive. The idea is most companies, they may have 10 executives, they may have 100 managers, they may have 1,000 employees at a different level underneath. And when the courts look at it, they're trying to determine how long will it take for you to find a job. If you're looking for a type of position where there's 1,000 of them at your competitors, it's probably going to be easier in theory than it would be if there's only 3 or 4 or 10 of those positions. So the courts look at that, but they don't really treat people fundamentally differently. You have a right to have compensation when you're let go, regardless of whether you're an executive or not. The only other factor that's important to keep in mind is executives often have very complicated compensation structures, and often it's very important for them to get legal advice to understand how that's going to be impacted on termination.
Okay, we're going to get into all of this because I know there are tons of questions about this topic. If you have a question for our experts, call us at 1-888-802-2016 or email us at askalawyer@cp24.com. Let's kick things off by taking our first email. Greg from Oakville had this question for our experts. I have been a senior VP in a company that operates in a relatively small industry where all of the key players know each other. Over the years, I have always felt trusted and respected by my company. I was recently let go and offered a package. I want to be careful that I do not burn any bridges in the industry. Am I risking my professional reputation if I see a lawyer and seek a better severance? I don't want to be seen as a troublemaker or someone who is litigious. What do you think of that, Matthew?
So, it's a common question in a way. It's a very odd experience for people when they've been let go from their employment, and especially when they're senior in the company. You always see yourself as on the inside. The company is not just something separate. I'm part of it. When you're terminated, suddenly you cross over to that line. Mm-hmm. You're on the outside. So it's hard to make that mental transition to say, well, now I have to look out for my own interests. What you have to remember in that circumstance is when the company decided to terminate you, they got legal advice, they got financial advice, they looked to say, this is in our interest. You have to do the same for yourself, and you will be respected for that. It doesn't mean you're aggressive, it doesn't mean that you make allegations that don't have a basis, but to say, essentially, I appreciate the offer you've made in the circumstance. I'm disappointed. Now I want to look to my rights. That's why you get your own legal help. That's why you understand your rights. And frankly, if you get a lawyer's advice, sometimes the advice is you've actually been treated fairly. You got a reasonable package from the employer. They treated you fairly, and you're one of the lucky ones. But if you didn't, and you got an unfair package, the company's trying to take advantage or just shortchange you, it's important to know. You want to be armed in the same way the employer knows what they're offering. You want to know, what offer did you get, so you can make an informed decision. How do I proceed with this?
Interesting. An executive and an employee seem to be at the end of their time at that specific workplace. Their ending seems to be similar, which a lot of people don't know about. So we're going to get into that as well. Kimberly smiling as we take this next question from Ashok in Mississauga. All of my previous employers have provided me with the technology allowance. The company that I just joined provides company phones and laptops. Should I use those devices for personal use or keep a personal phone and a computer as well? Kim.
So that's an excellent question. And as Matthew was saying, as you climb the ranks in, if you will, the pyramid, compensation packages become, more in depth. So of course, a technological allowance is something that's very important for someone to do their jobs. Laptop, iPad, cell phone, and it is so important to keep those separate. You use the allowance to buy what you need for work, and you use that strictly for work purposes only. And of course, you use your own money to buy yourself your own laptop and phone, because at the end of the day, it is the equipment and the property of your employer. It is not yours. So they have the right to look through your email. They have the right to look through your hard drive. They have the right to look through your cell phone, because it's not yours, it's theirs. And you are essentially just borrowing it from them. So it's really important in that respect. Sometimes we seem so comfortable at work. We're very close with our colleagues and our bosses. It's really important to keep that division strict, especially when it comes to the use of equipment.
Okay, that's a good rule of thumb for anybody across the board, any employee.
Definitely. And then when you get terminated as well, it's not such a hard adjustment, right? You have your own laptop and your own phone. You don't need to worry about getting a new one.
And your own email. Okay, here's an email from Vincent in Markham. I have worked at a telecom company for 7 years as a senior director. Almost half of my income comes from short-term and long-term incentive payments, which are paid out in early March. I was terminated as part of a restructuring on February 20th, as my HR rep told me that I am not eligible for my 2021 bonus because I'm not actively employed on the payment date. That seems ridiculous to me. Can I get that bonus that I earned last year? Matthew.
So this is a very common issue that arises. The default in law, and we have fought hard over the years to argue this before the courts, the default in law is, yes, you're entitled to your compensation. That's not just your salary. That's your bonus. That can be short-term incentives, long-term incentives, benefits, perquisites, all different elements of people's incomes. That continues over your reasonable notice period, over the time you get your severance package. For many people, the more senior they are in an organization, the more that their salary is not the primary component of their income. And a lot of the dispute comes around these other elements. What you have to look at in those circumstances is, what agreement do you have with your employer? What a lot of employers try to do, and they do so unsuccessfully when the employee is properly represented, is they say, well, there's a policy. We have a policy document that says that bonuses aren't paid even if you earned it all. They're not payable to you if you've been let go before the payment takes place. This is something we argue about constantly, but the law is very much in employees' favors. And in the majority of circumstances, especially when you didn't agree to that policy, you didn't sign on, you may not even been aware of it, you will get your bonus. You just may have to fight for it.
Yeah, it seems rather unfair.
Deeply.
Yeah, very unfair. Okay, let's take a short break. And when we come back, Matthew and Kimberly from Leckers Associates will answer more of your questions. Stick around.
Do you have questions about your employment law rights that you need answered? Ask a Lawyer is here for you. Every week, Leckers Associates disability and employment lawyers are taking your questions on a wide range of employment law topics. Call 1-888-802-2016 or send your questions to askalawyer@cp24.com. Watch Ask a Lawyer every Wednesday at 9:30 p.m. on CP24.